Bingo. Oh, we're up. I'm sorry. Technical difficulties.
Resuming after some Zoom technical difficulties. We have just a little bit of paperwork to review, and then we will have the public hearing in a few minutes later than normal. Has everybody read the meeting minutes from December 11th?
I
Does
have.
anybody have any comments?
No,
Comments? Okay, I don't have any comments either.
I'm gonna put a motion to accept.
accept the.
You know, motion to
Second.
accept, and we have a second, everyone in favor of accepting the meeting minutes from December 11th?
Aye.
The meeting minutes are accepted.
Yeah.
Anybody waiting?
Nope, not that I see.
No?
Nope. Just one participant. It's us.
Huh.
Oh, we're out there.
It's open.
It's out there. Oh, yeah.
Okay. um, Is Mr. McNaughton here?
Yes.
Okay. Just want to make, didn't want to start things if the, if the main participant isn't here. Okay. Okay, 7:05 PM on January 8th, 2024, and tonight we have a public hearing. I will read the legal notice for the record. The publication in the Westfield News from the Board of Appeals, Town of Southwick, released on December 26th, 2023, and January 2nd, 2024. Notice is hereby given of a public hearing to be held Monday, January 8th, 2024 at 7:05 PM. To hear the petition of Blue Sky Builders LLC for property located at 79 Mort Vining Road, Southwick, Mass. The applicant is seeking a variance for the use of a common driveway. This is a hybrid meeting to be held in the land use conference room where we are at Town Hall. Okay. Why don't you come on up and tell us what you got?
How would you like me to,
You can sit right there.
Wherever you want.
Or would you like one of
Pick-
the
pick-
You
rocking
can
chairs?
take a softer chair.
Well,
Yeah,
let's-
Yeah, it is. It's the nicest we got.
Whichever you
Put it that way.
prefer.
You guys ready?
I-
Okay. Well, my name's Kirk McNaughton.
Excuse me, sir, can you speak up, because I can't hear him back there.
Okay.
Sure.
Try
I can,
Tell you what.
I don't want to blow you away.
Hold on, hold on, no, no,
I can
hold
talk loud, yeah.
to project.
You can come right up here if you want. Yeah, no problem. Just let us know your name and your address.
Sit
Okay,
right
I'm
over it.
Deborah Griffin, I'm at 77 Mort Vining Road.
Okay,
Sit
Deborah,
right in
welcome.
that chair right there.
we're very friendly in public here. So,
I just want to be able.
yeah, I
to-
understand.
And may I ask a question before he starts?
Why don't we start first and then?
Then we'll have public
Well,
comment.
I have a question as to why he's representing this man here who owns the land. Why is Blue Sky representing Bill Smith who owns the land?
I can answer that.
Okay.
This is part of the hearing,
Right?
and we're letting him represent Bill Smith. This is Bill
He is
Smith.
not the owner of the land.
This is the owner right here.
That-
Right.
Oh, man.
It's,
Yes.
it's permissible to have someone that's not the owner of the property make the application on behalf of someone who is the owner of the property.
Okay.
Yes.
all right.
So since Mr. Smith and Ms. Nelson, I assume?
Yes.
Are here,
They're still in present.
they have given permission to Mr. McNaughton.
Then may I ask a question as to why the letter was presented with Blue Sky LLC as the one bringing the petition and not Bill Smith?
Because he is, Blue Sky is the petitioner or the applicant, but he's has permission to make this application from Mr. Smith.
Even though he is not the owner of the
Yes.
lake?
He's given, as
Yes.
long as we have permission.
You know,
I
this is
just want-
where we want everyone to have their chance
Okay.
to say something.
Yes, that's,
And if it goes like this,
No, I just want
Everyone's
to know
not-
why he.
you will have an opportunity to
That's-
say what you
that-
want to say, but let's not cut in and
that's,
we can.
this is perfectly,
Okay.
it's not the normal way, but it's an accepted way to do that.
Okay,
So, and anyone can make a application as long as they have permission of the actual landowner. Okay? All right, go ahead.
Okay, well, so, I'm Kirk McNaughton. I'm represent Blue Sky Builders. Just to give you a quick backstory here, you guys may or may not know that, I'm a builder. I build in the area. I'm out of, East Granby, Connecticut. And, I developed that property on Mort Vining Road originally back in the early 2000s. And, I guess because of that, and I'll give you a little more of the backstory as we go, but, Mr. Smith asked me, because he's encountered some problems with the, approval of this property, asked me to get involved, and as we started discussing things, we made an agreement that, I have the right to buy this property from him in the event that we're able to, get the, variance that we're seeking. So I have an interest in the, in the property, and that, I do have the right to buy the property at the end of the day. So that's just so you know a little bit of the background. And, so, basically what I plan to do tonight is really just kind of follow this, kind of follow the variance document that I had sent into you guys for the most part as an outline. So, as you know, we're here to seek a variance of the regulation 185-30.1E13. I'll try not to have to say that too many times. And that is specifically we're asking for the use of a common driveway to access an approved building lot. So as part of this process, we approached the building inspector to say, hey, we'd like to build on our approved lot. And the building inspector pointed out and indicated correctly, I think, that this regulation that was adopted in 2015 may provide a roadblock or prevent this lot from being built on. And we can kind of get into what the language of that is and how that affects this in just a second here. So, but we're appealing I guess we're appealing two things. We're coming to the board because the building inspector, also acting as a zoning enforcement officer, had indicated that there was a problem with the driveway. He also, in his letter, indicated that there might be a path to an approval by a variance through this board. So, again, I'm going to just kind of go from this written variance request that I submitted to you guys. So we're seeking relief from the building inspector, zoning enforcement officer's determination that this approved building lot's not currently buildable due to its access being via a common driveway that's currently serving two other lots. Our property is 79 Mort Vining Road, known as lot number 3. The other two lots are number 75 and 77 Mort Vining Road. Those are known as lots number 1 and 2. So the backstory here really is that in 2005, the town approved a common driveway to serve 3 lots, 75, 77, 79 Mort Vining Road. The common driveway was installed under the auspices of the town. They were very involved in it. The fire department, police department, the DPW. And it was a very extensive and lengthy process that we went through in order to build this common driveway to serve 3 lots. So back in 2005, after we got this approved, and you may be aware that just as an aside, I had a issue with the Conservation Commission. We actually had to sue the Conservation Commission. So, it was an uphill battle to get this project approved and get this driveway built and all that. But, we did reach a settlement agreement with the Conservation Commission, and that led to us getting the approval to build this common driveway. So back in 2005, we meaning Blue Sky Builders, I sold lots to 3 individuals, 3 approved lots on an approved common driveway. I sold 3 lots to 3 different individuals. The folks that bought number 75 and 77 Mort Vining Road, they both built homes in 2006. And Mr. Smith, who bought from me 79 Mort Vining Road, and Mr. Smith is here in the audience tonight. He bought it with the intention of keeping it as a long-term investment. That was his intention right from the get-go, and he did do that. And again, he purchased it as an approved lot, and he's been paying taxes on it as an approved lot. So the town assessment, the town is carrying it as an approved lot.
Undeveloped.
Vacant lot, but approved.
I don't think the assessor.
Right.
Cares whether it's a
Right.
buildable lot.
It's a piece of property, it's land.
Okay, well, that's fine.
That the Code of Assessors doesn't make that distinction.
Okay,
So go ahead. Go ahead.
yeah. Well, I know in some communities, if you had say a parcel of land versus an approved parcel of land, it might be valued differently, but that may not be the case here in Southwood. So, but in any event, he's been paying taxes on it since then. In 2015, the town adopted a new zoning bylaw dealing specifically with common driveways. Prior to 2005, there were no regulations about common driveways at all. So this bylaw states, and it was new in 2015, any existing common driveway in use at this time of the adoption of this section may not be used to access any additional houses. So I'm sure when this was written, that language was put in there for some good reason. I don't know why it would, because I don't know why it would really say that it couldn't be used for additional houses, but well, maybe because the bylaw talks about it only a 2-lot maximum on a common driveway. Okay, and then it goes on to say any existing common driveway in use at the time of the adoption of the section may not be used for access for any additional houses. So what happened was when the town adopted this bylaw, it really created a very unfair and significant hardship for Smith. Smith purchased an approved lot on a common driveway that was approved with a full intention of using it in the future for its intended use, its approved use as a residential building lot. And if the zoning bylaw is strictly enforced the way it's written, it creates a scenario where Smith is prohibited from building on his approved lot. He'd be deprived of his rightful use of the property, and as a result would use his value of his investment. He bought an approved lot at the time for $128,900 in 2005. So, and that creates, a significant hardship and kind of an unfair situation for Smith. And this variance process that exists is set up really for specifically for purposes like this, incidents like this, where crazy things happen that are not anticipated, but somehow have a negative effect on somebody, really in effect that wasn't intended when this regulation was created. So, we're asking the ZBA to grant a variance of that particular regulation to allow a third house in to be used on the common driveway. And, like we say here, and this is kind of talking to the language within the state, the guidance for ZBAs and the guidance for issuing of variances. Granting this would have no negative impact on the town and no negative impact on any individual. The driveway was constructed, as I said before, under strict town supervision to serve and accommodate traffic for 3 residents. And the 2 property owners sharing this common driveway, they took title to their lots subject to a mutual driveway easement and declaration that's filed in the town, in the land records in Springfield. And clearly shows and describes the common driveway to serve 3 residents. So nobody really would be injured or harmed. And if you were able to grant such a variance, that would undo the damage and reverse the hardship placed on Smith by the town's adoption of this regulation, and then it would confirm and protect his rights as a property owner and protect his investment he made in good faith in the town of Southwick. I mean, he just bought an approved building lot. He didn't expect that he'd have to be going through a process like this in order to use it. He had put the property on the market, I think, a couple of years ago, and had a buyer who came and was very interested in buying the property, and then ran into this hurdle that prevented the potential buyer from going forward, and thus kind of put it back and kind of led us to where we are today. So that's really our request at this point, is to just try to undo the hardship that the adopting of the zoning bylaw created.
All right,
Okay.
I have some questions here. Let me just jump in and start.
Sure.
I'm sure you're aware that we went through this in April.
I did see I'm aware of that, but I don't think, I mean, in my opinion, which is just my opinion, I don't think that the request for the variance was really very specifically laid out
Well, it
in
was.
that meeting.
I believe it was.
We
It was-
interpreted it as,
Yeah.
we interpreted it, we thought it was very detailed, and there's a
Okay.
lot of history that we went back and
Mhm.
and researched the town planner and the planning board and legal opinions and all that. So we had a very detailed discussion in
Mhm.
April. So I guess the question is do you have anything new to present to bolster your argument, or not argument, but to
Position.
to add to the position, or are you just relying on the existing information and documents that we had when we looked at this in April?
Well, I guess I could answer it a couple of ways. I'm not 100% familiar with exactly what documents you had in April. I'm not really sure exactly what information. I mean, you see what I brought. I have so many documents in so many ways. I could give you a lot of different things. I guess perhaps what I gathered, or what I came away with was, watching the tapes, was that the main concern of this board is, well, I don't really exactly understand how this even becomes a concern, but whether this driveway was approved or not. I mean, is that a thing that you're concerned with? Or, I mean, because it's obvious this driveway was clearly approved by the town. There's one fact that's really indisputable, that makes it really very black and white that it was approved. I know there's, you know, I've talked with the planner and I've talked to the building inspector and I've talked to a number of other people in the town and of course, the DPW, they were intimately involved at the time that this was approved.
Mhm.
I've got a lot of correspondence. I'm happy to submit this. I don't know if you've got, I don't know if you have everything or don't have everything. I'm prepared to talk about the approval in a number of documents in a number of ways. But I think the one thing that is really black and white is that, to demonstrate that this was an approved common driveway, okay, is
I'd
that,
like to jump in on my
Okay.
information of that, if you don't mind, Mr. Chairman.
Go
Good.
ahead.
Okay,
could
bill list.
I, before you say that?
Mhm.
Can I just tell you the one thing that's really
Yeah,
indisputable?
sure.
I think that would maybe clarify some things, right? So the folks that bought lot number 1 and lot number 2, they both built houses, right?
Mhm.
So the guy that comes in on lot number 1, he got the first building permit. Okay, so no common driveway really, in theory, is a driveway serving lot number 1. Okay, now when the guy comes in for lot number 2, if there's some question on whether that driveway is approved or not, at the time the guy for number 2 applies for a building permit, the only way he could get that building permit would be is if that common driveway was approved. If the common driveway was not approved, the building inspector could not or would not have issued a building permit. So the underlying question of, 20 years ago, was this driveway approved or not approved? That's really the fact right there. You could never have pulled the second permit
Mhm.
if it was not an approved common driveway. And then all the paperwork backing it up shows that it was always designed as a 3-lot common driveway. So the fact that the second permit was issued shows it's a common driveway, and all the documentation shows it as a 3-lot common driveway. So,
Okay.
thank you for
Fair enough.
letting me say that.
Just Throw one thing in.
Yeah.
You kept saying the town
Right,
approved it, the
right.
town approved it.
Yeah,
The town didn't approve it. There was a court case and there was a settlement agreement
Which I have.
Where?
We're gonna go over.
that you prevailed over the Conservation Commission that forced them to, I won't even say approve it, to force it to
Allow
go
it.
forward.
okay.
So with
The
that,
town, all these different
Right.
departments didn't approve anything, so.
so the comment, the indisputable fact, we didn't have a bylaw that covered common driveways when you bought the property.
Correct.
Okay. Such has changed in 2015, which was a town vote, by the way, so it had to be town adopted.
Mhm.
That they limited to 2 residential serving driveways on a common driveway.
Mhm.
Period. There
Mhm.
was, that was black and white. It's black and white.
Mhm.
Unless it was an estate lot, which when you were describing to get a building permit, if it was a estate lot, they could have done that before then, but
It wasn't. though.
it wasn't. Planning board had to issue a special permit. But there was a lot of work to be done to get those 3 lots served, 2 lots even served. And in 2005, you actually took it to court because conservation denied it. And you had a judgment in your favor with a plan that you put forth to construct these lots around the wetlands. And I'm going to quote the 2 key paragraphs in that decision. This was in Commonwealth Superior Court Civil Action 03-642 in May of 2005. Number 40 says the work authorized hereunder shall be completed within 3 years from the date of this agreement and final judgment by the court.
Mhm.
3 years. That'd be 2008. That you were supposed to construct all 3 of these properties to serve 3 driveways. The date of this work completed in the agreement may be extended by the commission for 1 or more periods up to 3 years with written applications commission in 30 days to initiate any extended work data established in this agreement. Such applications shall state what work has to be completed and reasons supporting the request for the extension. So doing that, you would have gotten to 2011
Well, I think.
as a maximum
Well,
to
I
do any
think the-
development on that property
Well, I think that.
based on your decisions of the conservation.
No, I understand.
To allow
what you're
it.
saying. I
To
understand.
allow it.
I understand what you're saying.
Okay.
But
But
I
this,
I don't disagree with I don't disagree with what the words are, but what I'm saying is that ruling dealt with the completion of the improvements.
to
that is the-
access those lots.
Yes.
So you did. And you
We-
complied, and 2 houses were built the next year.
It didn't even talk about improvements to the lots. It was improvements to the work to be done on the ground. It was improvements to the driveway and all of the impact for the wetlands, wetland crossings and all
Mhm.
that. It was the infrastructure work, not the houses. I don't think I ever said anything about the houses. That whole document talked
Right.
about the work, the project, the construction of the driveway.
Right, which would have, you had the opportunity to serve those properties, to your point, the 3 lots,
Well, they are all access.
until the zoning change happened in 2015, which then took it out of contention because you didn't do
What?
it between then.
No, I agree.
This was your window. I'm saying the window was up to 2011. You had to develop, or Mr. Smith to develop that lot. Now, whether if he was aware of that,
2011.
that's not-
Was 2011.
because you could extend that to get the work done to access those
Oh,
3
you're
lots, to
saying I had 3 years plus an extension.
take
we-
advantage of it. I
But
don't
we
know if you
did all the work in the first year or
Well,
year and a half.
There's not a driveway there, though.
No, it
2
is.
that built have driveways that service the lots. There's not a third driveway.
Well, there's the approval that we're talking about was really just for,
Where's the approval?
One-
Do you have that?
well, let me just say, the approval I'm talking about,
Hmm?
the settlement agreement that you're referring to was for the construction of the common driveway, not the
Right.
individual driveways on the individual lots, only the common
And we're
driveway.
not gonna argue that. You had
Okay.
access to 3 lots. And a time frame to use them, which became 2015 was the time frame because the town adopted a zoning bylaw that said no more than 2 houses on a common driveway.
Well, sure, I agree with that.
And that's where
you're
we're
saying
at.
it. That's the same thing I said.
But that's where we're at.
Yeah.
I can't change that.
No,
You could have changed it by having it
No,
developed,
you-
or Mr.
no.
Smith could have developed it
you can,
in that window.
I think you as a board can grant the variance.
Not with a lawsuit, I'm not gonna be comfortable.
Well,
with that.
then that's by your choice.
Mm.
But you have the option to, grant a variance over that particular regulation because by the town adoption of regulation, you created a hardship to Smith. He's just an innocent bystander here, really. Why, he's just he's just the one that's
Understand.
being put into a hardship, but, and if you really want to get into the details or the minutia of the lawsuit, believe me, I'm the person that can talk to you about that with firsthand experience and not give you a secondhand account of what happened. And the fact of the matter is, the town of Southwood Conservation Commission acted recklessly and wrongly. And as a matter of fact, the way the process works, I mean, if you want me to elaborate on this, the way the process worked was, they acted so improperly. We filed a complaint with the DEP. The DEP came out onto the site and they said, oh, you know what? They had what they called a de novo hearing. That is, they recreated the whole zoning, not zoning, but the whole Conservation Commission meeting on the site. And the expert from the state, who was the judge in this and all these matters, he came out to the site. And he said, you know what, usually we look at these matters and if we feel that this property can be properly built on,
Mhm.
we tell the commission to go back and think about this, review the information we're giving you and guide them to say, hey, you should have approved this. In this case, he said the town acted so improperly that I'm giving you permission right here, right now. I'm approving this on site today.
And
And
you have
so
that
when
person's
you-
name?
Yeah, his name is David Fowlis. He's well-known he's well-known. I've had other dealings with him. He retired, I think, a year ago or something like that, a year or two ago. He's around, but he came out and he specifically said, and the fact of the matter is they did act very recklessly. Here's what happened. This is how this all came about. This is stuff this is the stuff that nobody really wants to talk about. I came into the Conservation Commission with an application, okay? And the application to access these 3 driveways. And the Conservation Commission, just like, came in, talked to the board, had a discussion. And the Conservation Commission said, no, you know, we don't want to do this. You're creating too much of a problem. You got too much impact on the wetlands. Okay. And they pulled out the file and here's your denial letter. Okay, so before the public hearing, they predetermined before the public hearing that they were going to deny the application. They wrote the denial before the public hearing and they had it available to give out. That's totally against the law and totally improper.
But looking at this map, I can understand why. That's all
Let's do that.
wetlands and floodplain.
Well, you see,
No, the lot you're talking about, it's right in
Yeah.
the middle of the wetlands.
We're getting
But
off,
anyway,
yeah,
we're
well,
getting
just-
at a
no.
bit of a tangent here.
Yeah.
Because this
but
is-
that's
this-
why they probably had an issue, because
this is-
it's all wetlands.
oh, this is fine because there's plenty of room to have a driveway right here
What
a
happened in
wetland
two
crossing.
thousand five,
and a house
Yeah.
back here.
what happened in the
So-
details of 2005 isn't really what we're.
Well, the
What-
gentleman said because I brought a lawsuit against the
There was
against
a
the
time
town,
to
that
do
that
it.
would be a reason why you would want to deny a request for a variance. So I'm just saying, it's like, by you saying that, it's like our fault that there was a lawsuit, we acted improperly or recklessly to the
No,
town.
I'm just saying it was fact. It was a lawsuit, that's all.
But the fact
And it was a
is,
decision
it
for it.
was it was a fair lawsuit.
Mhm.
And the state came down immediately on us the way it was.
Mhm.
Ended up having to go to a settlement agreement because
Maybe that-
within this particular town, the Conservation Commission, they oversee the state bylaw. And then they duplicate the state bylaw as a town bylaw. So when they issue a denial, they issue it in two different venues. One, they denied under the state. And two, they denied under the town bylaw. But the town bylaw is the exact same language as the state. So that's why we ended up with a settlement agreement. The state said, blue sky, you're right, we're giving you the approval. And then then we said, well, we still have to figure out what we're doing under the Southwood bylaw. And everybody knew that if we proceeded, which we would, that the town would lose. So we did a settlement agreement. So it's not really our fault, it's just, I'm just here to try to
I
help
understand.
Mr. Smith and myself,
To your point, Sharon, as far as any other, I don't think there's new stuff we haven't seen it.
Let's hear from the.
Can I just-
people. Oh, go ahead, Mike.
On several occasions, you've said that we created, the town created a hardship for
Mhm.
Mr. Smith. And at one point, Mr. Smith could have built on that property. Where the hardship was put in was during that window of the 4 years that you had, 3 years plus the other year. That's where the hardship was created. At any point during that 4-year time span, he could have built a house there.
Sure, agree.
So by not building it, that's what created the hardship. Part of the law is that you can't create your own hardship. The zoning board of appeals can't overturn something that you created yourself.
Well,
And
there'd really be
so-
no way of knowing, there'd be no way of Mr. Smith knowing that, he lives in Hudson, Mass.
Right.
Maybe there was advertising, maybe he overlooked it, but the fact really remains is that no, I'm sure there was no harm intended and there was no ill will towards Smith, but the fact is the creating of that bylaw created the hardship for Smith, not the fact that he didn't build a house. You could buy a piece of property, you would have no expectation that you would lose your right to build on your lot. If you bought that lot and you decided you didn't want to build on it, you certainly would feel like you had the right to build on it when you got around to it. It was your lot. No way of knowing that they were going to change the rules.
By not doing it and not paying attention to what the rules were, you create your own hardship. You can't go back and say, I just didn't know what the rules were. That's not a reason to, I mean, if you have a property or a business, you have to pay attention to what's going on. If you don't, then you can't go back later and say, hey, I didn't know what was going on. Therefore, you need to change it.
Sure.
So, I mean,
Anyway. We're open for other comments.
Yeah, let's hear from the other folks.
Well,
that haven't-
We bought 77 Mort Vining in 2020. And we bought it, and he is correct, he did sign the statement or our lawyer pointed out to us a statement in there that said there was a possibility of a third building lot there to be built on. But we did do our due diligence and went and saw that the town of Southwick did not allow another building lot. So we proceeded with the sale of this home, knowing that that lot could not be developed into another home. So that being said, if this were to go through, the driveway was put in after our two homes were built. It's not rated to have cement trucks and lumber trucks going up and down. Had two culverts on this, I might add, that are just the regular traffic for car traffic on the
Yeah.
driveway. They're plastic culverts. They're not rated to obtain the weight of cement trucks and, logging trucks and things like that. So that's a concern on our part. It's a 15-year-old driveway. That's another concern for us as well. Another concern we have is the driveway is considered an easement, but we own at least 10 feet on both sides. So how does that work? I don't quite understand how he can cross our property to get onto his property. If the driveway was built and it drove into that property and hit that property line, I can understand it, because it clearly states the driveway is the easement. But to cross my property off the easement, which is the driveway, to access his property, that's a concern of mine as well. We've been maintaining that road, both the neighbor and myself. We've been maintaining that road, but like I said, it's 15 years old. It has two culverts that are not rated
He
to,
wants to go in, he wants to go in basically where that is, the solid line, where he wants to go in, I have to pull up my apple trees on my property. So I gotta redo and re-dig up my property to give them leeway to get into my property. Now, I don't know about you, but when I bought the property, it was my property. So I'm not digging up a 6-year-old apple tree just for you all to come right down.
but another concern is the utilities. We have underground utilities running the whole length of that driveway. So that's another concern as well. It's the utilities and the maintenance of the road. So. And like I said, we bought that property knowing that Southwick says only 2 per driveway. That's the only reason we bought that. Because it's all swamp, and it's even worse now. That perk was done many years ago. And I looked it up on Massachusetts law, and a perk is only good for 5 years. It's been there a lot longer than 5, and that property is much wetter now than it ever was.
Because from her pond, which is a pretty nice pond, her pond goes down into ours. That goes in, and then the neighbor across the street,
Had a culvert put in under the road.
Pete and Teresa on the other side of my road, they had a culvert, they spent a lot of money putting a culvert in.
Well, the
Well, that
town
culvert-
DPW.
Yeah, the DPW came in and they put it, now that culvert
Everything runs into.
runs into his wetland. Now,
Okay.
his wetland goes into that,
So-
which floods everything.
That's the planning board. We're
Right,
the
I
zoning
know,
board
I
of
know, I know.
appeals, so
but
you'd have to,
might add
Yeah.
as well, that he's stating that he had this property and he was kind of stuck with it. He had an offer on the table in 2020 to Erica Emmelman right there was gonna buy the property. The agreement was working through the progress, but then COVID hit. And then he backed off and put it up on the market again. So I might add that he had the opportunity to sell the property.
Ma'am, do you want to say something?
Oh.
Like name
Name and address,
and address,
Yeah,
please.
my name is Erica Emmelman and I'm at 81 Mort Binding Road, which is right next to
The driveway.
the property. And if you're looking at it, I'm on the right hand side. And I do have a pond and it is incredibly wet. But it does have frontage. There is frontage. So why can't they access that piece of property if they were gonna build on it from the front? Why does it have to go on a double driveway
It's all
in order
wetland.
to get
Wet.
It's all wetland.
It's all wet.
correct? But in order to put the driveway in, they had to go over wetland also.
It'd be a considerable construction endeavor to do that.
And, I tried to buy it not in 2020, but in 2016.
In 2015,
16.
2016.
2016, okay.
And your purpose was to put a buffer between you and the other, or you were
Just to
gonna
add
build on it, or?
popularity. I did feel bad for Mr. Smith because, you know, I don't need the property. I figured it would be a good thing to do. I wasn't gonna do anything with the property. I
Mhm.
wasn't gonna build.
All right, thank you. Anybody have any questions?
Yeah. Mhm.
Dan, no? Anything else to add, Bill?
Nope.
Mr. Chairman, I'm just wondering. I wasn't here for the last one. Was it denied?
It was withdrawn.
Withdrawn.
It was withdrawn.
I guess, I don't know if, I don't know if, how much, input you would take from, the folks' input here, but I did want to clarify some things. Would you like me to do so, or like, so?
Just one,
Yes, sir.
much of what they brought up would go before the planning board.
Mhm.
So what we're doing here doesn't have a lot to do with the culverts and the other things.
Okay.
So if you wanted
You're
to,
still gonna have opinion. We'll listen to everybody's opinion. It's
Yeah,
okay.
well, I was really just gonna say that the roadway there was in fact constructed in such a way that it would handle any type of a vehicle, concrete, fire truck, logging truck, lumber truck. It was already there built when the first two houses were built. They used that road for access, and there's very strict guidelines on that road. That was overseen by the town. That would not be an issue. The access over the lot is all spelled out in the document, so the right to the owner of lot one to utilize the common driveway to access to their property is clearly spelled out in the document. The underground utilities were already planned. As a matter of fact, there's stub utilities, a stub conduit anyway at lot number one. And the perk is the perk. I mean, if we got a septic system approved there once before, which we did, because we got septic systems approved for all three lots. Highly likely we'd get it approved again, but again, that's not really your thing. So that's all. I mean, it was built for three.
Okay. The issues that we typically deal with 99% of the time are dimensional issues. We deal with setbacks and lot areas, and so those are the kinds of things that we're asked to give variances on. We're asked to bend the rules. And in this case, I see this as a request to ignore the rule, ignore a rule that was put in place by the town at a town meeting. And I don't see it as something that we can approve. At least
Okay.
that's my opinion. It would have to come to a vote, but
Well,
it's too complicated of an issue for us just to make it go away with a snap of the fingers or a wave of the wand. So that's my personal opinion. The other members can comment on that or give their own opinions, but that's where I see my opinion on this issue. It's too much history for us just to make it go away. If you want to.
Kind of second that thought process, as well as that there was a lawsuit on it. There was opportunity to do things that didn't get done in a fashion that was allowed, with plenty of time allowed. And even the building inspector was kind of a no on this anyway, when you wrote the letter back to you.
because of the driveway.
Right, which same goes to the same
Because the
concept.
same, the same.
There was a
bylaw, yeah.
lot of layers to this onion.
Mhm.
And there's strict bylaw put in because of the common driveway issue the town faced.
Mhm.
And we didn't have any bylaw. So to go more than what the bylaw really specifies is not my popular opinion to do.
I also, are you finished?
Yes,
Yeah.
sorry.
I also think that there was an opportunity to do that, and the zoning board of appeals can allow variances when there's a hardship.
Mhm.
And I think part of what happened was that the hardship went by when they didn't build during that 4-year span. So the hardship that was created by not building during that 4-year span.
It's actually 6
Total
years,
6
Mike,
years.
but
I'm sorry,
it's 6 years.
Total of 6.
6 years.
3 plus,
Three
plus
plus
an
two.
option 3.
I'm saying, but they originally did
Yes. I
allow,
agree. I just wanted to make sure
Yeah.
the number was
So-
addressed.
Mhm.
6 years actually went by,
Sure.
but they did not build on that. So our right to grant a variance, we can't grant a variance when the hardship was created by the owner of the property.
Yeah, I'm a common driveway owner myself. I went to the planning board. I was the first common driveway after the bylaw was written. And I see it the same way with the opportunities that were had. And what went by. What Chris said, without the bend rules, not ignore or break them. So I see it the same way.
There's still an option to withdraw.
Yeah.
I'll offer you the option to withdraw the application, because it needs to be voted on unanimously in favor, so
Mhm.
I don't see that happening. So if you request the withdrawal, then we will comply. We will grant you that.
Which if it's voted on tonight and it's not approved, then you would have to wait 2 years before you could come back. Before,
Well, sure. Well, I get that. I mean, if we're going to be denied tonight, we most likely would be denied in 2 years as well. So I mean, the fact that we would get denied, I'll have to
just give
consult
you
with,
more
I will
options.
consult with Mr. Smith for a minute,
Yeah.
And I would like to say that, I do take exception to the, idea that Smith created the hardship himself. I personally, I mean, everybody's entitled to their personal opinion, and I'm not really saying that yours is wrong, but I don't agree with that really whatsoever. He's an innocent bystander. He paid $128,900 for a building lot. No way, no how would anybody here in this room would think if you bought a building lot that you would lose the right to use that building lot, or even really that, oh, you own this building lot, you should be keeping up, monitoring the fact that you could lose that right. I don't think anybody would really do that, but that's just my opinion. And then I did just want to address too, that, I know while you usually do, like you say, you usually work with issues having to do with, property dimensions and setbacks and, can we put the garage, over the building line or something like that, that, the state rules, specifically give the zoning board of appeal the powers to, hear and decide petitions for variances as set forth in section 10. Okay, that's of the section 10 of the Mass General Law.
Mhm.
And that says that, you have the right to grant specifically, under circumstances relating to soil conditions, shape, topography, land, structures, especially affecting such land or structures, but not affecting the zoning district which it's located, when a literal enforcement of the provisions of the ordinance or the bylaw would involve a substantial hardship. financial or otherwise, to the petitioner or the appellant, and that the desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating, that's their word, not mine, from the intent or purpose of such ordinance or bylaw. So under the state, you have the right to look at this bylaw and say that, you could grant a variance to allow that third house to use the driveway. You've got the right to do it. Obviously, you don't have to do it. It's up to you, but it's, even though it's maybe a little bit out of the norm, that's really what you guys are set up for, is to, when somebody has a specific hardship and it's unique to him. And, this fits like exactly like a glove, that you could grant that desirable relief without any substantial detriment to the public good or nullifying any regulation or bylaw. You have this in your power to do, and it's really just a matter of, poor Mr. Smith is really gonna be taken advantage of. He invested in the town of Southwood. I don't really understand. This is, again, just my opinion. I just don't really understand why you would deny this. It makes really no sense to me, but I understand that that's the way you want to do it, so.
Well, you wanna,
I would
wanna
say-
consult with you.
The next stop, what he takes. Okay, well, we'll let you take your vote. Hopefully, maybe you changed your mind in the 5 minutes since you said you were gonna deny it, but that's,
Prefer us to vote on it?
we prefer you to vote on it.
All right, I'll make a motion to deny the application for variance for common driveway for number 79 Mort Vining Road. A yes vote would be to deny the application. Mike
I'll
Parent?
second.
Oh,
No.
I'm sorry. You have a second. Mike Parent?
No. Oh,
Yes.
what?
If you want to deny the permit, vote yes.
Yes.
Bill List?
Yes,
Chris Mastriani votes yes. Unanimously choose to deny the permit.
Thank you for your time.
Yep.
Appreciate it.
Yep.
Thank you for a
Your input.
very organized presentation.
Yeah, thank you.
So John, I have a question. Does this mean he can come back every 2 years to appeal this?
Yes.
Plus, he has the right to go to court to, he has the right to go to court. We're the last,
We're clean anyway.
No.
it's okay.
But they'll be suing us, not you.
Okay, thank you
Yeah.
so much.
Okay, thank you. Thank you, folks, for coming and.
thanks for your input.
Sorry.
It's okay. You have to invite this lecturer up. If you want to say any comments here in the audience, but
Thank you, yeah.
any comment, Mr. Lecturer?
No.
None?
Any new business coming up? Okay, there's no new business, coming,
Got a motion to dismiss.
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 We have a motion to, which. I don't think it should,
I know,
to, we
adjourn.
have a adjourn. We have a motion
Motion
to
I was trying
adjourn.
to be fancy.
Motion to adjourn.
Motion. Okay, all in
Second.
favor, all in favor of adjournment?
Aye.
Aye. Yeah, adjourned.
Hello there, Mr. Mogul,
Mm.
Mogulin. Happy